So in the case of NS against Her Majesty the Queen, dans le dossier de NS contre Sa Majesté la Reine, Sharon O. and Andrew Nicol for the appellant, and Valérie Lafortune et Annie-Claude Autier pour les intimés. Très bien. Alors, ready to hear you. And you know you have 15 minutes, right?
Yes, Justice.
Okay, thank you.
Thank you. Good afternoon, Justices. My name is Sharon Au, and I'm here representing the appellant, NS, with my colleague, Andrew Nicol. Justices, this is not a simple question of evidence law. Rather, this case goes to the heart of the fairness essential to and required for the full functioning of our country's justice system. The moment we start placing restrictions on when and how an individual can testify is a moment that certain citizens are no longer equal in the eyes of the law. I will proceed by arguing that the court erred in finding that the factual record is insufficient to establish an infringement of the appellant's Section 2A rights. Next, I will argue that allowing the appellant to testify with her niqab does not violate the respondent's Section 7 and 11D rights. In the alternative, if there are competing charter rights, the appellant submits that the majority of the Supreme Court of Canada erred in incorrectly elevating the respondent's Section 7 and 11D rights over the appellant's Section 2A rights in the final step of the Dagenet-Mentec framework. Justices, would you like a brief summary of the facts?
I don't think we need that after having heard this appeal
Several times.
Good.
But just to be clear, in terms of the judgment appealed from of the Supreme Court of Canada, you are not asking us to adopt the position of any one of the, of Madam Justice Abella, in effect.
Yes, in effect, yes. We're asking you to adopt that decision with some minor caveats, which hopefully I'll be able to get to in my submissions.
Okay.
So, Justices, my first submission to you today is that the Supreme Court of Canada erred in finding that a Section 2A violation cannot be established on the existing factual record. Section 2A of the Charter guarantees everyone the freedom of conscience and religion. In order to establish a Section 2A infringement, the Supreme Court developed a two-step test in Syndicat Northcrest and Amsterdam. First, the applicant must demonstrate that her belief or practice is sincere and has a nexus with her religion.
How does an applicant do that?
Well, Justice,
From a
if I can...
practical point of view, what evidence needs to be led in order for a preliminary inquiry judge or a trial judge to make that determination?
Are you talking specifically about the sincerity of belief?
Yes.
So in paragraph 51 of Syndicat Northcrest, the court held that sincerity of belief is a low threshold and only requires the applicant to demonstrate an honesty of belief on the part of the religious practice that she subscribes to. So the second step of the Syndicat Northcrest test is that the infringement in question must interfere with the applicant's practice in a way that is neither trivial nor insubstantial. The threshold for establishing this infringement is extremely low. As a finding of fact, the preliminary inquiry judge in this case found that the religious belief was sincerely held. And so the issue in this case turns on whether or not the interference, specifically requiring her to remove the niqab, is either a trivial or insubstantial infringement on that religious belief.
But as you know, we're not bound by the judgment appealed from. And I appreciate that's what the majority said in Anselm and applied in this case as well. But were we to find that that threshold is unacceptably low, what would be an appropriate threshold?
Sorry, Justice, could you repeat that?
If we were to find that the threshold identified by the Chief Justice in this case was unacceptably low, what type of threshold would you suggest?
So I would suggest raising the threshold at the nexus with religion stage. I believe that the sincerity of belief is inherently personal, and it would be incorrect for the court to step in and essentially be an arbiter of religious dogma in determining whether or not the personal nature of religion is sincerely held. If this court chooses to raise the threshold that was established in Syndicate Northcrest and that has been followed in the Supreme Court of Canada jurisprudence, then it should be in the objective link in the nexus with religion. However, the facts of this case are such that there shouldn't be an issue with establishing the nexus with religion. It's undeniable that there are Muslim women who choose to wear a niqab because it subscribes to their faith.
And there are a majority of Muslim women who don't choose to wear a niqab, also who would, I would suggest, contend that they are equally sincere in their religious beliefs.
Yes, Justice, but nexus with religion shouldn't be necessarily determined by how many individuals in the religion subscribe to that belief or practice. Nexus with religion isn't necessarily defined by whether or not that belief is mainstream, but whether or not you can even establish that there's a group of people who hold that belief. So we would contend that a nexus with religion wouldn't be found if only one person held that belief because they thought that their religion required them to hold that belief. But the facts of this case aren't that. There are admittedly a minority of people who wear a niqab, but there are a sufficiently large group of Muslim women, at least in North America, who do wear the niqab and the burqa. So returning to my previous point, the issue in this case will turn on whether or not the interference requiring the applicant to testify without her niqab is trivial or insubstantial. And our submission is that it is neither. The factual record in this case establishes that the appellant's objection to removing her niqab is very strong. It shows that she's worn her niqab consistently for the past 5 years. It also demonstrates why she wears a niqab, specifically that she feels that showing her face to men that she would be able to marry would be tantamount to the disobedience of her God.
But I'm a little confused by that because the accused are not people she can marry. One is her uncle and one is a cousin.
Sorry, Justice.
And they're part of her family.
Yes, the accused are not people that the applicant or the appellant in this case can marry, but the defense counsel is someone she can marry. It's not someone in her family. Any of the courts.
But you're here.
Pardon, Justice?
You're here.
I don't understand.
Well, you're defense counsel, aren't you? Oh, no, defense counsel, excuse me. But defense counsel are both women.
Yes, defense counsel in this case are both women.
Well, this is the only case we're deciding.
Yes, Justice, but you and Justice Richard are both males, and there are other court staff in this room.
But they're not here, but your client is not here.
No, our client is not
She
here.
may be, as far as I know, but I mean, I don't see anyone with a niqab on in the courtroom.
Yes, Justice. But at the trial in which this preliminary inquiry took place, which is where we've obtained our factual record, it's entirely conceivable and possible that there were male courtroom staff, perhaps male audience members who came to see the trial, given that the courtroom is a public and open forum. And so in this case...
What about the fact that I understand she removes the niqab to drive a car?
My first answer to that question is that the driving a car is very different than testifying in front of a courtroom. Driving in a car is a very personal thing.
So is testifying.
Well, no, because when you're testifying in an open courtroom in front of men you can marry. It's a very uncomfortable situation. Courts have recognized that witnesses in general who testify may be uncomfortable because they're unaware of how exactly the adversarial process in the Canadian justice system works. But given that the appellant is an individual who has worn her niqab consistently for the past 5 years, she's someone who's not used to showing her face to other men who she can marry. Forcing her to remove the niqab in this extremely confrontational and adversarial system would not be a trivial or insubstantial infringement on her religious belief.
But your client is married, is that right?
Yes, Justice.
So how can she marry someone else if she's already married?
I'm unaware of whether or not it's possible, perhaps in Islam, for her to...
Do you know of any Canadian law that would allow a woman to have 2 husbands?
No, Justice. But it's not whether or not she's the determination of who she can show her face to doesn't turn on whether or not she's married. It's an overarching general principle. So in general, there are situations where there are married women who still can't show their face to the court or to the public. Given that there's 5 minutes remaining, I'll quickly proceed through my second submission, which is that allowing the appellant to testify while wearing her niqab will never be a violation of the respondent's Section 7 and 11D rights. For this submission, I have 3 arguments to make. First, the respondent does not have a constitutional right to the most comprehensive cross-examination imaginable. Second, cross-examination remains possible with a niqab. And finally, the ability of the trier of fact to assess the appellant's credibility is not sufficiently impeded to justify forcing her to remove her niqab. Beginning with my first submission, the respondent's scope of permissible cross-examination, although broad, is not unlimited. In RME, the Nova Scotia Court of Appeal held that the right to face one's accuser simply extends to the right of the accused person to be present in court, to hear the case against him, and to make full answer in defense to it. Even if the appellant in this case testifies while wearing her niqab, the respondent still has the opportunity to be in court, to hear the case made against him, and to make full answer in defense to it.
Well, how can you necessarily say that if full answer in defense includes effective cross-examination?
Justice, our submission to you today is that full and effective cross-examination remains possible. So if I can take you to my third argument, which is
I'm sorry, would you just repeat what you said to me? Full?
Yes, Justice. Our submission to you today is that even if the appellant wears her niqab, full and effective cross-examination
Remains possible, you said. I
Yes.
see, okay.
remains possible.
Well,
And the
does it?
reason for this...
Does it?
Yes, Justice.
Does it? Doesn't the witness's demeanor affect the cross-examiner's next question, potentially?
No, Justice.
No?
No.
Wow. All
Our-
the cross-examinations I did and the very careful attention I paid to the witness's demeanor was for nothing?
Well, Justice, our primary submission to you today is that demeanor evidence is inconclusive. But we
No,
recognize
I
the
don't
fact
mean
that...
I don't mean it in that sense. I don't mean it in the sense of the trier of fact looking at demeanor and saying, from the fact that you snickered a few times, I don't believe you. I mean it from the fact of the cross-examiner looking at the witness and saying to the witness, oh, you find my question funny, do you? Oh, you're blushing. Am I embarrassing you by asking you these questions? Doesn't the witness's demeanor perhaps inform the next question?
It could. And if the defense counsel wishes to use demeanor evidence in this case, there's other ways of assessing that demeanor evidence without necessarily seeing the appellant's face. So in the Ontario Court of Appeal decision in this case, Justice Doherty held that the appellant's body language, eyes, tone of voice, and manner in which she responds to questions all speak to her demeanor. So for example, Justice, if the appellant were on the stand and she paused significantly before responding to a question, that could indicate to the defense counsel that perhaps that's an area that could be explored further. If the appellant appears fidgety on the witness stand or shifts forward and backward uncomfortably, these could all be indications to the defense counsel to
Yes.
probe that area
Yes,
further.
they are, but in other instances, there may be others that here, these defendants will be deprived of.
Well, Justice, our contention is that these other methods of assessing demeanor are sufficient, especially given that the accused doesn't have a constitutional right to the most comprehensive demeanor assessment imaginable. In the Queen and Lyons, Justice Lafferay held that Section 7 of the Charter entitles the accused to a fair hearing, not the most favorable procedures imaginable. Now, there's numerous situations in Canadian jurisprudence where certain elements of demeanor are lost, and yet that evidence is still accepted in our courts. So the example that we've chosen to use is Section 14 of the Charter, where in instances where an individual who is a party to the trial is either deaf or does not understand the language of the proceedings, he or she may choose to testify through an interpreter. And in that case, certain elements of demeanor assessment are lost to the defense counsel and to the trier of fact. You can't pick up necessarily on the different voice inflections or even how or why the witness has chosen to pause. And yet our courts still choose to readily accept that evidence. This case is merely an extension of that principle.
Why don't you conclude with some final remarks, and then we'll hear your colleague.
Okay, so in conclusion, Justices, the factual record in this case is sufficient to establish a Section 2A infringement. However, allowing the appellant to testify while wearing her niqab would never be a violation of the respondent's Section 7 and 11D rights. What this comes down to is removing one small component of the demeanor package, itself a minimal part of the credibility assessment, which represents one tool in the cross-examination kit. Barring any further questions from the bench, these are my submissions.
Thank you very much. Mr. Nichol.
Good afternoon, Justices. My name is Andrew Nichol, and I will be addressing the appellant's alternative argument that if this court finds there are competing charter rights, the majority of the Supreme Court of Canada incorrectly elevated the respondent's Section 7 and 11B rights above the appellant's Section 2 rights within its analysis of the balancing step of the Dagenet-Mentec framework. Within these submissions, I will first illustrate how the Supreme Court of Canada was incorrect by highlighting the relevant legal principles and where its majority decision was inconsistent with these principles. I will then highlight the possible deleterious effects of a removal order on two vulnerable groups: sexual assault complainants and Muslim female victims of violence. Lastly, I will look at the impact a removal order will have on the appellant in this case. Turning first to the legal principles, the first point to make is that it is well established in the Canadian jurisprudence that the Dagenet-Mentec framework is the appropriate framework for reconciling competing charter rights. In the case at bar, 4 questions were asked correctly by the Supreme Court. My colleague has addressed the first 2 questions, whether there are competing charter rights. And again, in those submissions, we can test that there are competing charter rights, but for the purpose of this alternative argument, the appellant accepts that there is a risk to trial fairness for the accused. Moving to the third step, which asks, is an accommodation possible that will accommodate